The first time I met Marlene Hardwick, she was standing on my dock, clutching a clipboard like it was a sword and the lake was her kingdom. "You can't have that dock there," she barked, squinting at me like I'd dumped toxic waste into the water. I was holding a fishing rod and a lukewarm beer, still half unpacked from moving into the Lakehouse I'd bought 2 weeks earlier. "You're standing on my dock," I said, "and this property isn't in your HOA." She pressed her lips so tight they vanished into her face. Lakefront Estates HOA governs all properties on the North Shoreline. That includes this one. "No, it really doesn't," I said, tapping the county plat map I'd printed out. "This place is in unincorporated land. You've got no jurisdiction here." Her eyes narrowed. "We'll see about that." That was my first warning. I should have seen the storm coming, but all I cared about was finally having some peace. "My name's Russell Rayner, retired firefighter, bought this lake house to get away from city drama." I didn't expect it to follow me out here wearing pastel blouses and overly tight smiles. I didn't hear from Marlene for a few weeks after that, though I noticed a few more subs creeping past my driveway. Some of them slowed down, one even took photos. That one I waved at. He floored the gas like I'd pulled a gun. Then came the letter. It was printed on HOA letterhead and stuffed in an envelope marked urgent. According to them, I was in violation of Dock Compliance Code 4.7 and owed a fine of $600. I laughed so hard I nearly dropped my sandwich. I called the HOA office listed on the letter. A woman named Linda answered. "Hi, I'm calling about this ridiculous fine you mailed me. I'm not part of your HOA." There was a pause. Then, "Are you Mr. Rayner?" "Lakehouse on Ridge Point?" "Yep. You've been annexed into the Lakefront Estates HOA jurisdiction as of last month." I froze. "Excuse me," she cleared her throat. "A vote was passed by the board to expand our HOA limits to include adjacent properties. Your parcel is now within our authority. You can't just vote to take over private property." "It was a majority decision," she said, tone flat like she was reading from a script. "You're expected to comply with all HOA regulations moving forward." I hung up. Next morning, a bright yellow notice of non-compliance was stapled to my front door. That same day, a landscaper showed up claiming he'd been hired by the HOA to review acceptable vegetation. I told him he'd be reviewing the backside of my no trespassing sign real soon if he didn't leave. I started digging. Turned out, Lakefront Estates HOA had tried this before twice. Both times they'd failed, but this time they were sneakier. They filed a quiet annexation request with the county zoning office, buried in the back of a routine land use document. Only reason I caught it was because I requested every document with my parcel number from the county clerk. The kicker: my parcel was on a different tax code. Their annexation was invalid by default, so I lawyered up. My attorney, Miriam Huntley, was a pit bull in a cardigan. "They're bluffing," she said, flipping through the documents. "But if you let them push you, they'll bleed you dry." We filed suit to invalidate the annexation and bar them from further contact. That's when things escalated. One night, I came home to find my dock roped off with caution tape. A sign read, "Unsafe structure do not enter," again signed by the HOA. Funny thing, the dock was brand new. I'd had it installed by a licensed contractor 6 months ago. It was sturdier than my house. I installed security cameras the same night. The footage I got 3 days later showed Marlene, flashlight in hand, sneaking down my path at midnight and stapling another violation notice to my garage. That's when I knew this wasn't about rules. This was about control, and I wasn't about to give them any. HOA story, HOA stories, homeowners association stories. I didn't think Marlene would be bold enough to trespass again after the camera footage. But 2 days later, I caught her in broad daylight poking around the shoreline behind my shed. She had a tape measure in one hand and a laminated folder tucked under her arm. When I stepped onto the deck, she froze like a raccoon caught in headlights. "You lost?" I asked, keeping my voice level. She straightened up and tried to look official. "We're conducting a shoreline compliance survey." This area is considered part of the ecological buffer zone. No, it's considered part of my backyard. You've already been notified that you're not to enter this property. She held up the folder like it was a badge. The HOA has environmental responsibilities, Mr. Rayner. If your activities threaten lake health, we are entitled to intervene. Funny, that folder you're waving around still doesn't override private property law. She glanced toward the road, maybe hoping for backup. None came. You'll be hearing from our environmental subcommittee, she said, stepping back over the rocks toward the path. Make sure they know to bring a warrant next time. That evening, I forwarded the footage to Miriam. She didn't say much, just added it to the growing pile. The next morning, she filed an emergency injunction to bar any HOA representative from entering my land. The county judge signed it within hours, but the damage was already spreading. I got a call from my insurance agent. Someone had submitted an anonymous tip alleging that my dock was unstable and that I had unpermitted modifications to the retaining wall. My agent was required to investigate. That meant an inspection, which meant delays, red tape, and possible rate hikes. The inspector came out that Friday. His name was Alan, and he looked more annoyed than I did. "I've been out here before," he muttered, flipping through a thin file. "This is nonsense, but I gotta check the boxes." We walked the perimeter. He tapped a few beams, took some photos, and eventually shook his head. "Everything's up to code, nothing even close to an issue," he said, "but I'll need to file a report anyway. They've been calling non-stop." He hesitated. "The HOA. Well, technically a concerned resident committee, same 3 people every time." I didn't need names, I already knew. By the following week, Miriam had a full complaint drafted and ready. It wasn't just about the illegal annexation anymore. We were adding harassment, defamation, and attempted interference with property value. I reviewed it while sitting on my porch, watching the sun dip behind the trees. The lake was quiet, the kind of quiet I'd moved here for. Then came the fire marshal. He showed up unexpectedly, driving a county vehicle with lights on but no siren. I thought maybe it was an old colleague until he introduced himself. "Got a report about illegal fire pits," he said, flipping open a notebook. "Says you've got a wood-burning unit within 20 feet of a structure." I pointed toward the stone ring near the water. "That's 38 feet from the house." "Measured it myself when I built it." He looked like he already knew. "I'm not here to cause trouble, but the report said it was being used during a burn ban." "There's no ban right now, I know, but I have to document the complaint." He didn't cite me, just took a few photos and left. But the message was clear. They were trying to bury me in nuisance reports. The next day, I noticed that my mailbox flag had been bent backward. Not broken, bent. Odd, considering it was solid metal. A tiny thing, but it made my gut twist. I mounted a second camera facing the road. Within 72 hours, I caught what I needed. It was grainy but clear enough. Marlene's silver crossover pulling up beside my mailbox. Her passenger leaned out, reached over, and jammed something into the box, then tugged on the flag until it bent. I downloaded the footage, labeled it by date and time, and handed it off to Miriam with a simple note: "Escalating." She filed a police report. This wasn't just trespassing anymore, it was tampering with federal mail infrastructure. A felony. The sheriff's office sent out a deputy to take my statement. His name was Quinn, and he had the tired look of someone who dealt with neighborhood disputes too many times. "HOAs can be tricky," he said after reviewing the footage. "But this is over the line." "Way over," I said. "They don't even have legal standing here. They're not my HOA," he nodded slowly. "We'll investigate. You might want to consider protective surveillance for a while." I already had it. By week's end, Marlene received a visit from the sheriff's office. I didn't hear what was said, but the next morning, the usual HOA flyers that appeared like clockwork on my gate were conspicuously absent. 2 days later, I got a certified envelope from a law firm I'd never heard of. Inside was a cease and desist letter directed at me. It accused me of deliberate obstruction of community standards, public defamation of a volunteer board, and misuse of surveillance equipment to harass residents. I laughed, but Miriam didn't. "They're trying to flip the narrative," she said, scanning the pages. "Make it look like you're the aggressor. Standard intimidation move." "Do we counter?" "We do better than that. We bury them." She filed a motion to compel discovery on all communications between the HOA board members regarding my property. Emails, texts, meeting minutes, everything. If they refused, it would count against them in court. If they complied, we'd get the paper trail we needed. 1 week later, we received the first batch of documents. That's when it blew wide open. In a series of emails between Marlene and 2 other board members, they openly discussed a plan to strategically absorb non-HOA parcels in order to standardize lakefront aesthetics and ensure resale value across the entire shoreline. My name was mentioned 6 times. One message even suggested that constant pressure could force me to sell or conform. Miriam's eyes gleamed. They just handed us motive, intent, and proof of coordination. We submitted the emails to the judge along with our amended complaint. Now it wasn't just a civil matter, it was bordering on conspiracy to defraud. The court date was set for early August. Word got around fast. Residents who had once been silent started calling me. Some had their own stories, sheds torn down without warning, fines for garden gnomes, even a forced repainting of a house because the color was deemed too rustic. A man named George dropped off a folder filled with photos and receipts. They made me tear down my deck because the railing was 2 inches too high. Cost me $8,000. I gave everything to Miriam. We weren't just fighting for my land anymore. We were exposing a pattern. When court day came, the gallery was packed. Local news showed up, drawn by the recent police report and whispers of HOA overreach. Marlene arrived in a beige suit that looked like it belonged to a tax auditor. She didn't look at me. The judge took one look at our evidence binder and raised an eyebrow. "Miss Hardwick, your board attempted to annex private property without legal authority, harassed the owner, and engaged in mail tampering. Do you have counsel?" She did. A thin man with a comb-over who looked like he hadn't slept in days. He mumbled something about good faith efforts. The judge wasn't buying it. He ruled the annexation invalid, made the injunction against the HOA permanent, and referred the mail tampering evidence to the district attorney. He also granted me a restraining order against Marlene and any board member who had entered my property, uninvited. But the real blow came when the judge ordered the HOA to cover my legal fees in full and to issue a written apology, to be published in the community newsletter. The courtroom was silent. When it was over, I walked out into the sunlight, breathing easier than I had in months. A few neighbors clapped me on the back. George gave me a nod. Even the fire marshal showed up, tipped his hat, and said, "Glad someone finally stood up to them." I never saw Marlene on my property again, but a week later a for sale sign appeared in front of her house. The lake was quiet again, just the way I liked it. The day after the court ruling, I sat on my porch with a mug of black coffee, watching a pair of mallards glide across the lake. For the first time in months, there were no unsolicited notices taped to my door, no subs creeping past my house pretending not to stare, and no strangers poking around near the shed. The silence had weight to it, like the lake itself was finally at peace. Then around mid-morning, I got a call from a woman named Teresa Klein. "You don't know me," she said quickly, "but I live 3 streets behind Marlene. I saw what happened in court. I've got something you need to see." I met her that afternoon at the old bait shop near the marina. She came in carrying a folder that was practically bursting at the seams. Short, with graying hair pulled tight into a bun, Teresa looked like someone who used to teach middle school and had zero patience for nonsense. "I was on the HOA board until last year," she said, sliding the folder across the table. "I resigned after they started pushing for what they called visual continuity. Inside were printed emails, photos, and what looked like internal budget sheets. They used HOA funds to hire a private contractor to survey parcels outside our jurisdiction, she whispered. They told us it was preliminary research for a beautification grant, but it wasn't. They were compiling a list of properties they thought they could pressure into joining. I skimmed the documents. One memo detailed a strategy to target absentee owners first, then move inward. Another contained a list of parcels labeled with terms like low resistance and non-compliant aesthetics. I looked up. Why bring this to me now? Teresa's eyes flicked toward the window. Because I think they went farther than you know. Check the last page. I pulled out the final document. It was a scanned invoice from a private security firm, Stonebridge Risk Consultants. The service listed was discrete surveillance and environmental compliance photography. The billing address. Lakefront Estates HOA. Photographing people's private property without permission, I asked, my jaw tightening. Not just photographing, she said. They had someone watching homes. I found out when I spotted a guy crouched behind my fence with a camera. He took off when I yelled. The invoice was dated 3 months before the court case. That meant while they were sending me fake fines and trespassing, they were also paying someone to camp out and document my every move. I handed the folder to Miriam that same night. She paged through the documents like she was reading a confession. This changes things, she said. If they used HOA funds for this without owner approval, that's fraud. If they used it to surveil non-members, that's criminal trespass, maybe even stalking. She drafted a formal complaint to the county prosecutor. Within a week, investigators began interviewing Teresa, George, and a few other former board members who came forward. One of them, an accountant named Becca, handed over a USB drive with financial spreadsheets that weren't part of the HOA's public disclosures. It showed that over $50,000 had been funneled through a community development discretionary fund, with barely any oversight. Nearly half had gone to Stonebridge. Then things got ugly. The president of the HOA, a man named Carl Denslow, who had somehow stayed in the background until now, tried to claim the documents were fabricated by disgruntled ex-members. But he didn't realize that Stonebridge, facing pressure from the DA's office, had already confirmed the work order. Carl was arrested 2 weeks later for misuse of HOA funds and unlawful surveillance. Marlene was named as a co-conspirator. The charges were read aloud at a community meeting attended by over 100 residents. Carl tried to argue with the officer as he was being cuffed. Marlene stood frozen, clutching her handbag like it might shield her from the consequences. Someone in the back started clapping. Others joined in. After they were escorted out, a man stood up and asked, how many homes were they watching? The answer, when it came, was 23. Residents started demanding audits, and the county agreed to oversee a full forensic review of the HOA's finances. What they found went beyond surveillance. There were payments to a landscaping company owned by Carl's nephew that had billed 3 times the market rate. A community event fund that had no receipts. Even a legal consultation fee paid to a firm that didn't exist. By the end of the month, 5 board members had resigned. The HOA was placed under court-supervised management, and a temporary administrator was appointed to clean house. But for me, it wasn't over. The surveillance contractor had taken more than just pictures of my dock. They'd captured images of me on my porch in my backyard, even through the windows at night. I only saw the photos because the DA's office showed them to Miriam during discovery. You want to press charges? She asked. I didn't hesitate. Absolutely. The contractor, under pressure, provided a chain of command detailing who ordered what. Marlene's name appeared on every request involving my property. Carl's signature was at the bottom of each invoice. The DA added stalking and invasion of privacy to their charges. In court, Marlene tried to plead ignorance, claimed she thought the photos were for insurance documentation. The judge wasn't having it. The evidence was too clear. She was sentenced to 90 days house arrest, 2 years probation, and a $5,000 fine. Carl got a year in county jail. The new HOA administrator reached out to me directly. "Mr. Rayner," she said over the phone, "we understand you've been through a lot. We're offering to formally remove your parcel from any future notices or outreach." "Put it in writing," I said. They did. Legal language this time. Signed, notarized, and filed with the county clerk. My property was now officially listed on public record as exempt from Lakefront Estates' HOA jurisdiction. Permanently. One evening, as I was stacking firewood behind the house, I heard footsteps on the gravel drive. I turned, half expecting another unwanted visitor. Instead, it was George carrying a cooler. "Brought beer," he said. "Figured you might want to celebrate." We sat on the deck, watching the sun hang low over the water. He opened 2 bottles, handed me one, and raised his. "To peace and quiet," he said. I raised mine back. And holding the line. A few more neighbors joined us that evening. No one said much about the court case. We didn't need to. That chapter was closed. A week later, I got a letter from the county. They were launching an initiative to audit all HOAs in the region for financial transparency and adherence to jurisdictional boundaries. Apparently, my case had stirred up enough attention to warrant a broader look. Teresa called to let me know she'd been asked to help with the oversight committee. "Guess I'm not quite done fighting," she said. "Neither am I told her. I decided to join the committee myself. Not out of spite, but because if there's one thing I learned from this, it's that silence is how power-hungry people move. I wasn't going to let that happen again. Not on my shoreline. It was early autumn when the county's oversight committee held its inaugural hearing in the old Civic Center near Town Square. The place hadn't seen a crowd like that in years, folding chairs filled to capacity, neighbors leaning against walls, reporters scribbling notes in the margins of their notepads. Even the mayor showed up, though he kept to the back row, arms folded, listening more than speaking. I sat near the front beside Teresa, who had been officially appointed as a civilian liaison for the audit process. The air inside buzzed with a mixture of anticipation and unease. People weren't just there to talk about Lakefront Estates anymore. Other communities had come forward, places like Maple Hollow and Birch Run, each with their own stories of board overreach, financial inconsistencies, and intimidation tactics. One by one, homeowners stepped up to the microphone to speak. A woman from Birch Run described how her HOA had levied a fee on every household to build a community center, only for the proposed site to sit vacant for over a year, while funds vanished into a maze of vague contracting agreements. A retired veteran from Maple Hollow recounted how his backyard flagpole had been declared a visual obstruction, and his refusal to remove it led to daily citations until he threatened to file a civil rights complaint. It was hard to listen without feeling the old heat rise in my chest. When my turn came, I stood and walked to the podium, unfolded the statement I'd prepared, and looked out at the crowd. "I came here looking for quiet," I began. Instead, I ended up in the middle of a campaign to force conformity through pressure, lies, and manipulation. The HOA that targeted me didn't just bend the rules. They rewrote them in secret, enforced them without authority, and used private funds for surveillance. But they didn't count on one thing: people paying attention. The room fell still as I laid out the timeline, every letter, every trespass, every scheme. I didn't embellish. I didn't need to. The facts were weight enough. When I finished, I folded the paper and stepped down. No applause, no cheers, just silence and nods. That was better. It meant they were listening. The committee adjourned after 6 hours. That night, the local news ran a segment titled "Unchecked Power: HOAs Under Fire." Footage of the hearing played behind voiceovers describing the wave of investigations now sweeping through the county. According to the anchor, the district attorney's office had opened 4 new cases that same week. 2 mornings later, I received a call from Deputy Quinn, the same officer who had taken the original mail tampering report. "You got a minute?" he asked. "Sure. You need to hear this from me first. We executed a search warrant at Lakefront Estate's old community office. Found a locked cabinet with documents that weren't disclosed during the financial audit. Some of it pertains to you. I felt my grip tighten on the phone. They kept a second ledger, not just for your property but for others too. It includes payments to third parties that never showed up in the official books, and one entry. It references a compliance contractor paid under the table to apply pressure on Ridgepoint holdout. That's you? What kind of pressure? That's the thing. The contractor isn't licensed. No business registration, no tax filings, just a name and a burner phone. Goes by Douglas Shear. The name didn't mean anything to me, but I didn't like the sound of it. We're tracking him down, Quinn continued. But here's where it gets worse. One of the payments was labeled Interior Assessment, dated 2 days before your power went out last month. I hadn't mentioned the outage to anyone. I'd chalked it up to a blown breaker. But now, are you saying they broke into my house? We think someone did. No forced entry, but a smart lock can be bypassed with the right tools. We've requested access to Stonebridge's full client list, but this Shear guy never worked with them. He's off the books. My stomach turned. I'd been watched, harassed, and now possibly someone had stepped into my home without me knowing. The investigation moved quickly after that. With the second ledger in hand, the DA's office charged Carl Denslow and Marlene with additional counts: criminal conspiracy, wire fraud, and unauthorized surveillance. But the big surprise came when they arrested a third person, Douglas Shear. Turned out he wasn't just a freelancer. He had a sealed record from out of state for breaking and entering, and had been paid cash through a shell company registered under Carl's name. Douglas confessed to entering my home while I was away. Claimed he was only checking for code violations, whatever that meant. But he also admitted to installing a small device in my attic, a motion sensor camera that fed to a remote server. I didn't even ask what it had seen. I had it removed and destroyed the same day. The charges against Carl now carried the weight of felony burglary and illegal wiretapping. Marlene, despite claiming ignorance, had signed off on the payment requisitions. She was indicted on conspiracy charges and was later found guilty in a bench trial. Carl took a plea deal. 18 months in prison, plus restitution. Marlene received 6 months incarceration and a 5-year ban from holding any position in any HOA or nonprofit board within the state. The homeowners of Lakefront Estates voted to dissolve their HOA altogether. The new administrator had little interest in trying to salvage what was left, and most residents had lost all faith. The community agreed to return to county governance, sparking a wave of similar votes in nearby associations. A month after the final sentencing, I got a letter in the mail. Not from a lawyer, not from the county, just a handwritten note on lined paper. It read, "We didn't know the full extent. Thank you for standing up. You gave the rest of us the courage to speak." No name, no return address, just a small envelope that spoke volumes. I joined the Oversight Committee officially that December. Not because I liked meetings or policy debates, but because there were still people out there who didn't know they had a choice. People afraid of retaliation or too exhausted to fight. Teresa and I worked to draft a new set of county guidelines, ones that required full financial transparency for all HOAs, mandatory third-party audits every 2 years, and a ban on private surveillance funded by association dues. We called it the Homeowner Protection Charter. The county board passed it unanimously. In the spring, I hosted a small cookout at the lake. Nothing fancy, just neighbors, burgers, and a few folding chairs around the fire ring. No permits, no complaints, no citations. Just people enjoying the space they owned. Someone brought a guitar. Someone else brought a cooler of sweet tea. At one point, a boy skipped a rock across the water so smoothly it looked like it might never stop. As the fire burned low and the stars came out, I looked around and realized something. This wasn't just about winning a case or exposing corruption. This was about reclaiming the idea that where you live shouldn't come with fear. That a home, especially one by the water, isn't something anyone should be able to control with threats, fines, or backdoor deals. I'd bought that Lakehouse for peace. And now, finally, I had it earned, not given. Guarded, not gated.